Joining us now on Skype is Mallory Quigley, Vice President of Communications for the Susan B. Anthony List, and John Bursch, Senior Counsel for Alliance Defending Freedom. Welcome to you both. John, let's start with you. Can you summarize what exactly the Supreme Court will be considering in Dobbs versus Jackson Women's Health Organization?
A very exciting case. It involves a Mississippi law that protects life beginning at 15 weeks gestation. So at that point forward, the state values the life of the baby and the health of the mother to such a degree that no abortion procedures will be allowed. And the Supreme Court needs to decide whether a state has the ability to regulate abortions after the viability line. That's something that previous court decisions have been confusing about, with the court suggesting that maybe you can't do that, but yet upholding other pre-viability laws, such as those that prohibit partial birth abortions. And so this will be a case that significantly clarifies abortion jurisprudence in this country.
John, so quick follow-up. Is it accurate to say this Supreme Court case directly challenges Roe versus Wade's decision?
Well, I would say it challenges some of the logic of the decision. I don't think anyone should be expecting that Roe versus Wade will be overruled or overturned, because Mississippi's request to the court to hear the case didn't even ask them to rule in that way. But what it does do is it attacks one of the crucial logical underpinnings of Roe, which is this viability line, which doesn't really make any sense, because as science advances, the ability to allow a baby to grow and develop outside the womb later or earlier in the pregnancy increases. And so the life that you could protect in the 1970s is not as much life as you can protect today, which is not as much as you'll protect 20 years from now. So that line really should go.
Mallory, in the effort to end abortion in the United States, how significant is this Supreme Court case?
I think John explained it so beautifully. This is such an impactful moment, because this Supreme Court case is going to allow not only the litigators, but pro-life activists, pro-life personalities in the media, and just, as we're talking to our friends and neighbors, to talk about what abortion laws look like in this country and get at the reality that the United States is one of only 7 countries worldwide to allow abortion beyond all the way up to the moment of birth. And so getting at this extremism and how it is not reflected, the will of the people to protect life is not yet reflected in our laws. This case is going to provide so many opportunities for conversation, education, and changing hearts and minds.
Mallory, as John explained, this case centers around viability and whether abortion can be constitutionally banned for babies who cannot yet survive outside the womb. What's your pro-life response to that big question?
Yeah, well, the pro-life response there is there really isn't anything that separates, the child who can feel pain, who is able to live outside the womb from, just a little bit earlier. Like, all of these lives they have the same inherent dignity and value. And who do we want to be as a nation? Don't we want to protect the most vulnerable among us? And so it allows us to just begin conversations with our neighbors about where they would draw the line. And as we have these conversations that are going to mirror what how the conversation goes down in the court, I think you'll find people that are just kind of starting to question, that core premise of Roe versus Wade. Is a baby's viability outside the womb, is that the marker of when they become a unique individual worthy of protection?
That's beautifully stated. John, a lot has been made in the mainstream media about Justice Amy Coney Barrett's judicial philosophy on abortion. This is her first major abortion case at the Supreme Court. But what's her past record on this? Do we have a clear picture on how she might rule?
Well, we don't have a picture of how she'll rule in an abortion case, simply because she hasn't really had one, certainly not in the Supreme Court, but not even in a significant way in the Court of Appeals, where she used to serve. But we do know that she is an originalist, a textualist in the mold of her mentor, Justice Scalia. And if you look at the U.S. Constitution, there's nothing about abortion in there anywhere. This is a right that was completely made up by 7 members of the court in the 1970s. And so we would naturally expect that she would be somewhat hostile to that viewpoint, that you can make up as a judge the rights that you want in the Constitution. But really, this isn't one that should come down to any one judge's philosophy. When you're talking about babies that can suck their thumb, feel pain, blink their eyelids, move around, and even use their taste buds to taste whatever their mom is eating, This is something that everybody should be able to agree on. And that's why the overwhelming majority of Americans support restrictions that protect life in the late terms of a pregnancy.
Absolutely. Mallory, we have less than a minute left, but the White House signaled it might fight any Supreme Court ruling that limits abortion. Could the administration or Congress take action that would stifle the effect of a potentially pro-life ruling from the court?
There's no doubt in my mind that the Biden-Harris administration and their pro-abortion allies in Congress will do whatever they can to further enshrine abortion on demand. So we will keep an eye out. They're already looking to dilute the Supreme Court by expanding more seats and creating more judges. There's been legislation introduced. The White House has set up a commission to discuss this. They'll take any opportunity they can to dilute any pro-life good news that comes out of this case.
Well, thank you both for joining us. It's a big news week. Thank you for breaking it all down for us. Mallory Quigley with the Susan B. Anthony List and John Bursch with Alliance Defending Freedom.